In this video, I'm going to talk about things to follow while valuing the contingent claims of an EPC company. Hi, my name is Yash Shah and I'm part of the leadership team at SJA, the first entity to have gotten the license for valuing all the notified asset classes under the Companies Act 2013. In the last 30 years, after completing the valuation for numerous EPC companies on behalf of large banks and financial institutions across the country, including for companies having order books in excess of 10,000 crores and projects scattered at more than 100 locations across India, we decided to make a video on valuation of contingent claims. So these are the things to do. Number one, you have to collate a comprehensive list of all the claims. This collation should contain name of the project, the unique project code, nature of the works, amount of the claim, unique case number if the claim is in court, the forum before which it is pending, the date of filing, the date of last hearing. This will become a comprehensive database and a comprehensive dashboard for all the factual information which you will need in making the valuation model. Number two, calculate a theoretical resolution date. Now, one very important thing which we as valuers should understand is that we do not have to step into the shoes of the judicial authority. We do not have to become the judge and start looking into the facts and merits of the case in order to assess a realizable value. Especially in a country like India, where you have a district court coming up with a judgment which is then subsequently overruled by the Honorable High Court, and then sometimes that is also overruled by the Honorable Supreme Court. And ultimately you see that the government comes out with a retrospective amendment nullifying the entire thing by saying that we clarified our original intention. And then things go into international arbitration, pressure is put on the country. So what I mean to say is that we do not have to enter the shoes of the judicial authority. But what we have to do is that we have to collate statistics from reliable and credible sources. Like various studies have been published by credible bodies quantifying the average time period required to reach a decision in India for such claims. This quantification is based on the forum at which the dispute is presently pending. For example, one such study is done by the Planning Commission of India, which reports the average resolution time for resolution of contractor claims or EPC claims in India, depending on the present forum at which it is pending. If it is at the arbitral tribunal or is it at the district court, the High Court or the Supreme Court. So it is a statistic which is there. And Planning Commission of India reports are obviously reliable and credible data which we can use as inputs for our valuation model. So using that, we have to come up with a theoretical resolution date for the various claims that we are about to assess. Now number three, you have to calculate a realizability coefficient or a risk-based discount factor. Now this coefficient requires exercise of expertise and fact-based judgment by the valuer. Some sources and this input and how you derive it may depend greatly on the facts and circumstances of the case, or may even depend on the industry. If you are doing this for a road developer, or you're doing this for someone who makes bridges, or you're doing this for people who are engaged in water projects. So it may depend. Like if I give you some examples, some sources of this coefficient can be studies on past success rates on similar matters. Now there's a plethora of literature. These days everything is online. So you have all sorts of judgments and case laws which you can peruse and mine to understand that how certain matters are progressing towards certain realizabilities. That is one source of data. Now there are also numbers reported by judicial forums. Like if I give you an example, for NHAI claims of road developers, a committee was formed which was called the CCIE, Committee for Conciliation of Independent Engineers. Now whatever matters this committee has taken up and the kind of realizability that has been there for the contractors, it is in public domain. So that data can be collated to establish, okay, on an average, what is the kind of realizability on similar matters. Another good source could be in case you have access to legal opinion, in case your consultancy firm has an in-house legal team, or the client for which you are doing this exercise already obtained a legal opinion on the matter. That can also be used as an input for coming up with this realizability coefficient. Step number 4. you have to calculate the costs and expenses associated with the action. Now you have to understand that in a system like India, which is slow and somewhat inefficient judicial system, where resolution of disputes is not only a time consuming but also an expensive affair, an estimate of legal expenses may be drawn based on various factors like number one, past expense ratios of the company on legal matters. That can be used as an input. There can be a perusal of the standing legal retainer contracts of the company. If the company is already having certain advocates on retainer, those contracts can be perused to come up with an estimate of how much legal expenditure will be incurred. And there can always be reference to studies which are there on average legal expenditure, like the study I cited above of Planning Commission also goes ahead and quantifies what is the quantum of legal expenditure which is incurred in reaching a judgment depending upon the forum at which the dispute is pending. Now step number 5, you have to calculate a discount rate and ultimately come up with the present realizable value of the claims. Once all the above ingredients are ready, an appropriate discount rate is to be calculated. This can be cost of capital if the assessment is being done for the management. It can be the marginal lending rate in case you are doing this assessment for certain debt holders or banks, financial institutions. It can even be the opportunity cost of marginal funds if the assessment is being done for some potential investor. Using the above, so you have the listing of claims, you have a theoretical resolution date, you have average legal expenditure which will be incurred, you have your discount rate, and you have a realizability coefficient. Once you plug all this into your model, you can come up with an estimate of the present value of contingent claims. Now, this is just one of many approaches which one can follow for valuing contingent claims in any company. This was more towards an EPC company. So I've added a link to the description box of the Niti Aayog study which I cited in my video. You can click on the same to download and use it. And this is Yash Shah saying goodbye. And as always, I'll see you in my next video. Thank you.